Hello everyone. Today we would be discussing mandatory injunctions. Mandatory injunction is governed by Section 39 of Specific Relief Act. It is a positive form of injunction and it is granted to prevent a breach of legal obligation. It requires the defendant to do an action. It aims at restoration of the things to the previous status. Therefore, it cannot be granted to create a new state of thing. We can understand mandatory injunction by way of an example, where government has built a road which has encroached into the land of plaintiff. In this case, the plaintiff can apply for mandatory injunction to ask the government to remove the part of road encroaching into the land of plaintiff. Now we discuss the principles underlying mandatory injunction. A mandatory injunction can be granted only in a case where plaintiff shows a very strong probability based on the fact of the case that grave damage would be caused to him in the absence of injunction. Mandatory injunction is a equitable relief where the plaintiff shows that his right exists, which requires assistance from court. It is also a discretionary relief where the plaintiff brings before the court that damages alone would not be sufficient for the injury caused to him. Now we discuss the circumstances which warrant grant of mandatory injunction. First, there must be an obligation on part of defendant to perform certain acts. Second, breach of obligation must be alleged by the plaintiff. Third, plaintiff shows that grave damage would accrue to him in future and compensation awarded for such damages will not be sufficient and adequate. Fourth, such relief must be enforceable by court so that it does not require any continuous surveillance from court. We can understand this by way of an example. Mandatory injunction cannot be granted in a case where direction has been sought for daily cleaning of road. Now we discuss the circumstances where mandatory injunction cannot be granted. First case is where equally efficacious relief is available and can be obtained by any other mode of proceedings except in case of a breach of trust. Second situation is where the conduct of the plaintiff itself has been like that to disentitle him to be the assistance of the court. For example, it can be delay in seeking relief by the plaintiff or acquiescence by the plaintiff, where the plaintiff has no personal interest in the matter. After discussing mandatory injunction in detail, now we try to understand the difference with respect to alternative remedy available for the same situation. Take the example of recovery of possession. The remedy can be availed either by filing mandatory injunction or by filing suit. The difference is with respect to limitation and court fees. For mandatory injunction, the limitation period is 3 years, while for suit, limitation period is 12 years. Likewise, for mandatory injunction, fixed court fees are payable, while for suit, ad valorem court fees are payable. This series would be continued further to explain important aspects of injunction. This would be helpful to all the individuals, including professional in legal fields. Do continue to watch our series and share your feedback by way of comment. If found helpful, please like and share as much as possible and subscribe.